Hello, everybody. This is Samantha from the Law Offices of Samantha Wolfe, and I'm here today to bring you our next virtual seminar. So today we're going to be talking about being a virtual nomad. For anyone who's wondering, you can always check out our virtual seminars on our YouTube channel, which you can access directly through our website, or you can go directly to YouTube and just look us up. We have a channel there. You can look at all of our virtual seminars. But today we're going to focus on virtual nomads and how to determine what state governs your estate planning documents. So I'm going to go ahead and share my screen here. All right. So today's title is Estate Planning for Digital Nomads. So I'm trying to come up with a fun title. Really what we're just talking about is determining domicile, where you live, and why that matters. So we're going to go over some introductions, some definitions, determining domicile and why it matters, managing assets across multiple jurisdictions, key legal tools for digital nomads, tax planning essentials, practical tips and best practices, and then we'll answer some questions to wrap us up. So let's go ahead and get started today. So when we're talking about a digital nomad, we're talking about those who might work remotely, might be retired individuals that move frequently between states. We have snowbirds. We have people who live in Pennsylvania half the year and go down to Florida half the year. And so these individuals may have multiple bank accounts in different states, and their domicile may even be in question, which state's actually their domicile. And it is a growing trend. We have more remote work opportunities that have led to increase in digital nomads worldwide. Individuals can work remotely for companies in other states. Retired individuals may have multiple homes in multiple states that they treat as seasonal retreats. So that's where our snowbirds come in. So let's dive into this, because more and more I'm seeing clients that actually do have properties in other states. So it presents unique estate planning concerns. Multiple jurisdictions may apply. So different states have different laws about inheritance, property rights, and probate. So we need to be familiar with that. We need to think through the asset location. So if it's real estate, where is it located and does that matter? Investment, bank accounts, personal property might be spread across different states. And then we have to think through the tax complexity in our estate planning documents. So let's start with, why does domicile matter? So domicile versus residency. Domicile is your legal home, which really kind of determines your estate and tax obligations. Residency is where you temporarily live or work, which can change. So again, when we're talking about our snowbirds, there's always a state of domicile. That's the state that would govern what estate planning documents and where your tax obligations are. But you may reside in Pennsylvania and in Florida, Pennsylvania and in South Carolina. Now, the implications of domicile is determining which state is your domicile will determine which laws apply for estate taxation and probate. Not probation, probate. There's a potential for competing claims from multiple jurisdictions unless you know for sure where your domicile is. So let's think through, how do we determine your domicile? A lot of this is based on facts and circumstances. So some factors that suggest your domicile are going to include, where do you vote, where are you registered to vote, what state issues your driver's license, where's your primary address, where do you spend the most of your time, what state do you file income tax returns in. All of those factors are going to weigh into which state is actually your domicile. Now, the critical step is making sure that once you determine where your domicile is, you want to make sure you're aligning your estate planning documents with your official domicile to avoid legal disputes. So for example, if you're domiciled in Pennsylvania, you want to make sure that your estate planning documents reflect PA law and abide by PA law, because that's where you're domiciled. And it's a big deal in Pennsylvania because Pennsylvania does have an inheritance tax, so other states may not. So if you're domiciled in Pennsylvania, it may mean that your estate is subject to inheritance tax, where if you had your domicile in Florida, there might not be inheritance tax. Now, again, we have snowbirds. Seems like the most common is Pennsylvania and Florida. And clients will talk a lot about, well, should I change my domicile? You have to think through, are you willing to change all of the different things? Like, are you willing to change your driver's license to be Florida? Are you willing to change your voter registration to Florida? Are you going to now start filing Florida state income tax returns? Is that your primary residence? Is that where you spend the bulk of your time? So all of those things are going to weigh into whether or not you can change your domicile to a state other than PA. But it does seem like the trend is to change your domicile to another state because Pennsylvania has inheritance tax and other states do not. Now let's talk about managing assets across multiple jurisdictions. So the first thing you want to make sure to do is have a list of all of your different assets. Real estate, bank accounts, brokerage accounts, business interests, personal property, what institution, what's the account number, all of that good stuff. You want to make sure that you're consulting with your attorney to find out what are the rules, what's the inheritance tax rules in the state, what are the gift tax rules, what are long-term care options. Florida, for example, has stronger protections for long-term care, meaning that if somebody needs long-term care, there's a lot more protections in Florida than there are in PA. So again, knowing that is really important. Some things to keep in mind, some states have inheritance or estate taxes that will affect your assets when you die. So if you can claim a state other than Pennsylvania, for example, you might want to do that. But it may mean that you have to change how you file taxes, where you vote, where your driver's license is through, all of that. So it's not a simple thing. You have to make sure you have all of those facts and circumstances aligned that would make sense for you to change your domicile. Okay. We have clients that Pennsylvania and Maryland, they might have property. They might live in PA, have property in Maryland. They might live in PA and have property in West Virginia. We have one client that lives in PA but has property in Delaware. So you want to think through, when I die, is there a way for me to avoid probate in multiple states? So a revocable living trust would do that. This would avoid probate in every state where you own property. So for example, in the situation where you have property in PA and in Delaware, you would have to file probate documents, whether it be ancillary probate or whatever, in both states. Where if you create a revocable trust and transfer your PA property and your Delaware property into the trust, you've avoided probate in both states, which can make it a lot easier to administer your estate. So that helps a lot. So when I have a client that has real estate in multiple states, even if they could do a will-based plan, it might be beneficial to do a revocable living trust. So in that case, I had a client, like I said, with Pennsylvania and Delaware. Pennsylvania is their domicile state, so the trust is going to be administered according to PA law. But because we put the Delaware property in there, we don't have to file an ancillary probate in Delaware when they pass away. So it makes it much more cost efficient, much more streamlined. Now, you still probably want to do a pour-over will. In fact, I say probably, but I always do a pour-over will, even if we're doing a revocable living trust, because it might capture assets that a client forgets to retitle, or a client forgot they had, or acquired after we did the revocable trust. So you're going to pour it over into the trust. So even if you have a revocable living trust, you still have a pour-over will. You want to make sure you have a durable power of attorney, healthcare directives, whether it be a healthcare power of attorney in a living will or whatever it is, so that you're outlining your medical wishes. So you want to make sure you have that. And anymore, you can store them or carry them digitally, access them digitally. And now with health portals, you can upload them to your health portal too, which makes it easier. When you're talking about business interests like LLCs or other entities, you want to think through, the LLC helps centralize the management. Same thing where, then it makes it easier rather than having all these parcels of real estate. It's just the LLC that you can do things with, and figuring out what state you want to register that LLC in can be really important. All right, tax planning considerations. So lifetime exclusion through the end of 2025 is 13.99 million. Now that doesn't matter where you reside, what state you're domiciled, doesn't matter. It's 13.99 million for federal gift and estate tax purposes. So whether you're living in Florida or whether you're living in PA, it's 13.99. In 2026, that will increase to 15 million. So no matter what state you're in, you want to think through, how does federal gift and federal estate tax apply? Same thing with the annual exclusion, the $19,000 that you can give every year to as many people as you want. That is a federal rule. It doesn't matter what state you are domiciled in, that $19,000 can be given. And you can give it to someone in another state if you want. Now you want to make sure that if you give gifts above the $19,000 that you're filing a 709, a gift tax return, so that you can show that you made a gift, but you're allocating your lifetime exemption to it, so there's no tax. And that's no matter what state you're in, you have to do that. The annual exclusion limit, 19,000 per recipient. The domicile and situs planning, you need to know whether your state has an inheritance tax or a state estate tax, and doesn't match the federal estate tax. So you need to make sure that you're thinking through that. You also want to make sure that you're thinking through what the LLC rules are, because that would be a great way to make transfers at a discounted rate if you would need to do that. So those would be other things you want to consider. Common pitfalls and guidance. So let's talk about things that you want to be aware of. So if you have an unclear domicile, it causes disputes over which state should handle the probate and taxes. Another common pitfall would be outdated documents. So it could be that the law has changed. It could be your circumstances have changed. So an older will might fail to address new assets that you might have acquired. It could be too that the law has changed. Pennsylvania, we've had law changes. So you want to make sure that wherever you're domiciled, you're updating documents. Now, another common pitfall would be missteps when preparing documents. So not disclosing out-of-state assets or planning documents to your attorney. At our office, we always give new clients what we call our intake worksheet, where we ask them to list all of the documents, and that's so we're not missing anything. Because again, if we have somebody that has real estate in another state, we want to know that, because it means it's going to be subject to probate in multiple states. So we want to make sure that we're updating documents. We want to make sure that we have all of the appropriate provisions in your documents. And again, each state is different. So for example, powers of attorneys, I'm licensed in both Pennsylvania and Maryland, and they have different requirements about provisions that are in there. So you want to make sure that you're consulting with your attorney, even if you don't need to update them. I have clients that might have moved from Maryland into PA, and they just have me look at them to see if it complies with PA law. So that way they're not caught in a situation where their document, you needed a power and it's not in there. And if I review it, it could be that there are no changes that need to be made, because even though you drew them up in Maryland, it still works for PA law. Now, practical tips and best practices. You want to make sure you're storing your documents, your wills, trusts, POAs. You can secure them online. There are databases that you can pay to store online documents. You can also just store them online. Like sometimes I have clients that ask me to send them electronically, and then they store them on their phone or in their email, so that way they have them. You want to make sure your executors or trustees know where to find them, know who to contact if they have questions. And then revisit your estate plan every 2 to 5 years, just to make sure that your plan aligns with your goals and accounts for your assets. So if you have your documents, you still might want to do a new intake sheet in 2 years to make sure that we've captured all of the assets. And then if you would have international law implications, that's where we want to bring somebody in that can help with that. But usually you can have a team around you that's your advisor, financial advisor, your accountant, and your attorney to make sure you have the best estate plan in place. Okay, frequently asked questions. This is always a good session. Do I need separate wills for each state? The short answer is probably not, usually not, but you might want them. So if you have a well-drafted will, it's going to be valid in all 50 states. However, there might be certain specifics that a state requires. So for example, in PA, if we have an out-of-state executor, if the will doesn't waive bonds, the executor has to post bond in order to serve. So again, it's not that the will was invalid, it's just that you have to know that specific provision in PA. And so again, it doesn't hurt to have an attorney review it just to see if there's any tweaks or updates that need to be made. If you have real estate, mineral rights, anything like that, that's where you want to make sure you're thinking through, because as soon as you have real estate located in Pennsylvania, even if you aren't domiciled in Pennsylvania, all of a sudden inheritance tax is now a possibility. And so you want to make sure that you're thinking through that. And you may want to name an executor that has boots on the ground if there would be real estate located in a different state. So you want to think through that. Next one is my will still valid if I no longer live in the state in which it was written? The answer is yes, generally it's still going to be valid. So a will would be valid if you did Maryland and moved to Pennsylvania. So again, you just have to know that each state has certain specifics. So for example, self-proving, in Pennsylvania, if you have two witnesses and notary, it can be self-proving, but the requirement would be that in Pennsylvania, you don't have to have it be self-proving. It just has to be something in writing that you've signed. So again, knowing what makes it easier to administer in each state can be really helpful. So may mean you don't have to redo them, but you might want to consult with an attorney who is licensed in the state where you are moving to. So the executor rules is exactly what I was talking about. Some states restrict out-of-state personal representatives or require a bond. Pennsylvania is one of them. Marital property regime change. That would be common law versus community property. Pennsylvania is a separate property state. So if you're moving from a community property state, you want to make sure that you're consulting with an attorney to make sure you're addressing those. And then ancillary probate, that would be if you have property in another state other than where you're domiciled, it may make you subject to ancillary probate rules. So again, that's where a revocable trust could be really helpful, because then it avoids the ancillary probate. Next question, how do I decide which state should be my domicile if I spend equal time in multiple states? So we talked about this a little bit. So factors that the court and authorities would consider is, where do you intend to return permanently? Where are you registered to vote? Where do you pay taxes and file your state returns? Where do you hold your driver's license or vehicle registration? What's your mailing address? Club memberships and community involvement. They're going to look at all of these factors. You can only have one domicile at a time, even if you have multiple residences. So planning tip, if you spend equal time in all locations, you want to consult with your attorney to see which state offers you the best tax structure, because that might help minimize taxes for you. Be consistent across legal documents, tax filings, and registrations. The other question I get a lot is, can one spouse be in one state and another spouse be in another? And so the short answer is that maybe, but if you are married and filed jointly for income tax purposes, that's going to be very difficult to achieve. So usually, if you're married, it's going to be the same state for both of you. Next question, how often should I review my estate plan while I'm frequently relocating? Short answer is every time you establish a new domicile. you should have your documents reviewed. So confirm your will, trust, and powers of attorneys align with that state's execution requirements, with the taxes, and with the fiduciary requirements. And the rule of thumb is get them reviewed within 6 months of establishing the domicile in that state. And most of my experience, if I review a document and it doesn't need changed, I'm not going to change it. Okay, so you just need to make sure you're talking with a legal professional and asking them, do I need to change it? Is this something that needs to be changed? You want to make sure you're having your estate documents reviewed anytime there's a significant life event. So if you're buying or selling real estate, opening or closing a large retirement account or a bank or brokerage account, maybe there's a marriage, divorce, birth, or death. Could be that it relates specifically to you, but it also could be that it's the beneficiary or your executor that's had this major life change, and so you need to revisit your estate planning documents. Routine checkups. If you move frequently but keep the same domicile, then you just want to make sure that you're every 2 years you're looking to confirm beneficiary designations, the trust funding, address changes, all of that good stuff. Make sure you haven't acquired any new documents that you need to have a beneficiary or that you need to transfer into a trust. And then conduct a full attorney review every 2 to 5 years for any statute updates. Now, at our office, we do try to notify clients if there's been a big law change, but it doesn't hurt for you to meet with an attorney every 2 to 5 years, even if your domicile has stayed the same. Next question is, will my 401k, IRA, or life insurance beneficiary designations need to be changed after I move? No, they remain valid nationwide, so you don't need to change them unless you want to change. Like, for example, if a beneficiary, if you were updating it because something has changed with the beneficiary, you changed your mind about the percentages, they have a new address, they've gotten married, all of that. So just because you move doesn't mean you have to change the beneficiary designations, but you might want to do that if there's been a life event change. Okay. Let's move to our next one. Oh, wow, we're done. So thank you so much for joining us. We have our address listed there as 20 East 6th Street, Suite 206 in Waynesboro. And you can reach us at our number at 717-655-2676 to schedule a consultation. And what I will tell you is that I'm always happy for clients to bring their documents in. I'm happy to review them if they've moved states. And like I said, if there are no changes, then they don't have to change their documents. The only reason they would need to change is if there's something that doesn't comply with Pennsylvania law, or if they want to do long-term care planning and we need different powers in the power of attorney, because maybe Maryland or wherever state they were in had different requirements. So I always try to explain, if I'm recommending a change, why I'm recommending it and what the change should be. So in the world where we're moving so much anymore and you can do so much remotely, it's always good to try to figure out what state is the one that applies. So if you have further questions, like I said, reach out to our office. We do have a website where we have a direct link to our YouTube channel, and we do have additional supplemental information. We do quarterly newsletters, so you can find links to those newsletters. And then, like I said, there is a link to our YouTube channel, so feel free to check that out too. We always try to do virtual seminars, so if you have any ideas, please let us know. We'd be happy to talk about a topic that you might have questions about. And thank you so much for joining us. I really appreciate it, and hopefully you found this very helpful, and we'll see you again soon. Bye-bye, everybody.